We will definitely will accept, but there are some very strong decorum which is maintained by our High Court. 150 years decorum.
Yes.
The decorum is that when the seniors are there, the juniors always wait for their turn to mention. Give the slip, we can't, but at least who is your senior?
Mr. Sogoto Mitra.
Has he not taught you the decorum of the court?
Yes, yes, sir. Also, I'm deeply apologize.
Please, that's the tradition. Preserve the tradition. Don't disturb the tradition. Yes.
My lord, may I mention one application? There is some urgency. Urgency is, my lord.
Urgency before my lord, do it.
My lord, may I permit to mention one matter, my lord? My lord directed to file the paperwork to the
Whatever you want, what?
to be mentioned, my lord, they have not filed the paperwork till date.
Give.
Lord, may I crave your lordship? My lordship was pleased to pass an order.
What is that
Directing
application or what?
It's a contempt application.
Contempt, give.
My lord, arising out of your lordship and the Honorable Justice, my lord, Prosenjit Biswas, my lord.
Anyhow, let us see. I am not available nowadays.
My lord,
give.
pensionary benefits, my lord, I have not.
Whatever, let us see. Yes. What is there, sir?
Your lordship, may I permit to mention restoration application substitution.
So first appeal, my lord, it's ready for hearing, my lord. Paperwork is ready.
Give, we don't know.
My lord.
With my lords, kindly may I be permitted to this matter. This matter is appearing as item number 266. This appeal has arisen out of section 18 reference case of Land Acquisition Act, my lord. My order dated 17th 11/2023. This my lords directed me to withdraw the entire decretal dues by giving 50% security and 50% without security, my lord. My lord, there was also direction to file an affidavit of undertaking that in case the amounts gets decreased or increased, I shall be liable to return it back, or I shall be liable to take it back, my lord. My lord, in the meantime, I've submitted my bank guarantee, my lord. The department is saying that since file is lying before my lord's court, my lord, we cannot permit you to
It
withdraw,
will
my
go
lord.
down. Just mention it will go down.
Lordship, may I be permitted to mention one matter for inclusion in the daily list?
What is that matter, sir?
This is FAT 351 of 2023.
What is the appeal? Nature of the appeal?
This appeal is arising out of the final decree passed in title suit 1460 of 2009.
What is that final, this title suit?
That title suit is disposed and
What is the nature of the play?
civil.
Title suit always civil.
Oh, sorry.
It's not a criminal matter in a title suit.
Sorry, my lord. It's an first appeal.
I understand. First appeal from which decree?
From the final decree.
Final decree passed in what proceeding?
Passed.
Apart from title suit, what proceeding? What is the nature of the proceeding?
No, it is. Sorry, my lord. It's a partition suit, my lord.
Final decree has been passed.
Yes, my lord.
Has it been engrossed on the stamp paper?
Yes, my lordship.
Engrossed on the stamp paper?
Yes.
Then what remained?
The petitioner is aggrieved by the final decree and wants to challenge the final decree, lordship.
Which year?
It's passed in 2018, lordship.
Give the slip.
Grateful, lordship.
Dear Lordship, for the dismissal of the appeal for non-prosecution.
Oh, always welcome.
May I permit to mention, your lordship, for inclusion, your lordship, application.
Application?
Application is for in
whatever application. It's an application.
Yes, your lordship.
Your lordship, it is an application
Yes.
running in the supplementary list.
Lordship, on application.
Yes.
Just come at 5 minutes. Now, your lordship was kind enough to call for the original workload record and লিস্টের একটা নাম্বার ভুলে আছে নাম্বার ভুলে আছে?
ঠিকই আছে সুস্মিতার নাম ঠিকই আছে
This has come at my instance. Your Lordship was kind enough to call for the original record to find out my lord, this is that matter, my lord, where my lord, some fabricated document has been filed and on the basis of the same interim order was obtained. Now your Lordship was pleased to my lord dismiss allow my appeal.
Then why it is mentioned?
Lower court record, as your Lordship directed that the lower court record be kept with your Lordship's file in a safe custody.
That's not when it's lower court
Record is with the file, my lord, original file.
has to be gone down before the learned court below.
Disposed of them. But since the work of record was called by us, so they wanted that there should be a direction.
That's been order.
Hey, lower court record has come.
No, not that. It is it is in a yellow envelope file. Lower court record.
How could you know that it is in the yellow?
For your Lordship's court, we have seen, my lord.
So it might have been kept somewhere else in another envelope. The matter is mentioned.
Another thing, my lord. Kindly see the last part of your Lordship's order.
20,000 has been deposited.
2 lakhs.
2 lakhs have been
Not-
deposited.
No.
কত মানে still মানে she used to get 4,000. She has managed কত 1,96,000. 4,000 she is to get by next week. So we will deposit by by next week.
1,000.
4,000.
4,000.
Shortage.
Council like Mr. Dhar is appearing. And for 4,000. What is this? Is it it is a believable one for 4,000? She is waiting. Could engage both of you.
Draft. Draft has been given to my learned advocate on record, my lord. Only 4,000 is to come, my lord. Then we deposit the bank draft.
Are you sure about yours?
Yes, yes.
For 4,000, if then I have a lot of doubts.
সকালে দিয়ে গেছে today morning, my lord, it was given to my learned advocate on record, my lord.
Because my lord, unless your Lordship extend, my lord, they will not accept. Order was passed long back.
আরে ভাই ছাড়ো না উফ। গরিব মানুষের কাছ থেকে 2 লাখ টাকা নিয়ে নিল।
তোর racket চালাচ্ছিস?
This matter is mentioned by the counsel for the appellant that the trial court is unable to proceed with the matter as the lower court record has been called for in connection with the instant appeal and is lying in this court. By an order dated 13th October 2023, we disposed of the appeal containing certain observations as evidence therefrom. Since the appeal is no longer pending before this court, let the lower court record arrived to this court be immediately sent down through special messenger at the cost of the appellant. You are the appellant or
Appellate.
at the cost of the appellant. Such cost shall be put in course of this day. The we further we had imposed a cost of rupees 2 lakhs to be deposited with the state legal services authorities within 3 weeks from the said date. Mr. Dhar, the learned advocate, appearing for
Respondent plaintiff.
respondent plaintiff submits that the respondent has arranged the money, but could not be deposited unless the time is extended. In such view of the matter, time to deposit the said costs, COSTS costs, is extended by a week from date. For the purpose of record, this matter shall not be shown pending in the docket of this court.
But the only thing, my lord, if I deposit the cost, let the same be sent down within a week. Otherwise, my lord, we have a experience that, my lord, we are depositing the.
We have said immediately. What more? In the week means immediately.
Deeply obliged.
I was six. Six, what is it? Six.
Right, number 5, my lord, I am for the appellant, my lord. This appeal was admitted by your lordship on 17th of October. My lord, I do not know, my lord, why the matter has come. If your lordship can see the order.
No. Let it go out of this. Actually, this is SA 96. It's wrongly gone as SA 98.
Oh, for that reason.
He sent it to be printed as SA 96. The printer has committed a mistake according to him and said 98. That is the mistake.
Then no order shall be passed, my lord.
No, nothing. Let the matter go out of this.
I agree.
Yes.
Let's subject to the due of the court, my lord.
I beg to apologize. In fact,
20 rupees deposited.
Miller?
20 rupees deposited.
yes. Now, what is my reciprocal submission? Issue is at particular point. Matt suit was dismissed for default. The word default. Now, according to Oxford Dictionary, default is meaning failure to appear. Failure to appear. In my case, it is not applicable because I have appeared and court has passed the order. So basically, Milord, what is my reciprocal submission? The word default, either it is applicable to me or not. Now, at this point, Milord, covering, it is now covered under Article 227 also, Milord. Covered under Article 2. This is a supervisory power of the court. Milord, I appeared before your appeal bench. At this point, my respectful submission, Milord, if your lordship allow me to take back this one and to file the revisional application under Article 227.
We don't know. why we will create a jurisdiction. There is another line of judgment which says neither the jurisdiction can be created by consent or the agreement of the parties, nor can be created by a judicial order when that court lacks inherent jurisdiction. So how can we pass an order?
Leave may also be granted.
Simpliciter withdrawal, we can definitely appreciate it. Simpliciter withdrawal,
Take back the original.
but we will not make any comment on that.
One.
Now the fallacy, I tell you, you said the Webster's dictionary, Oxford dictionary, Black's Law dictionary, Stroud's dictionary defining the default. I understand. Have you ever come across with the provision of Order 17, Rule 2? Have you come across? Read Order 17, Rule 2. Order 9.
Procedure if parties fail to appear on the day.
Correct. No,
Where on any day which the hearing of the suit is adjourned,
Correct.
the parties or any of them to fail to appear, the court may proceed to dispose of the suit in one of the modes directed on behalf of the order 9 or make such other as it thinks fit.
Now, then you'll have to read Order 17, Rule 1. Conjoint.
Court may grant time and adjourn hearing.
Correct, sir.
The court may, if sufficient causes is shown, at any stage of the suit, grant time to the parties or to any of them, and may from time to time adjourn the hearing of the suit for the reason to be recorded in writing.
Another, there are many.
Yes.
Sub Rule 2, many are there. Read. Those read. So, in the event if the adjournment is refused, the court wanted to proceed. The parties said, I will not proceed. Then Rule 2 says that it will be deemed that the party has not appeared, and then he can take recourse to under Order 9. Why this Rule 2 is introduced is that suppose if there is already a substantial progress shown in the suit, many witnesses have been examined, some of the witnesses are supposed to be examined, or in case where the defendant has admitted some of the part of the claim, then in that event, the court may not dismiss under Order 9. The court may pass a part decree. The court may pass such an order. There is no fetter on the part of the court in doing so. Here, he has exercised under Order 9. If he has exercised under Order 9, then under Order 9, Rule 8, if the dismissal has come, then I am asking you a very simple question, whether an appeal lies against the order of dismissal.
Subject to the leave of the court. Here the issue is that dismiss for default.
That is why that's why Rule 2 I said the two options are there. One is the court may proceed under Order 9, or otherwise you have not seen those languages. Look at Rule 2.
Yes, Rule 2.
Yes.
In every such case, the court shall fix a day for the
No.
hearing.
Then he can proceed. Thereafter, he can proceed under read.
Hearing of the suit and shall make such order as to cost occasion of the adjournment or such higher cost or
Correct. Either under Order 9 or otherwise. So he has chosen Order 9.
Use an Order 9.
Now Order 9, Rule 8. Good, different, bad, we are not going into this. First is whether the first appeal lies against the order of dismissal. Under Order 9, Rule 8. That was the first question I put it to you without entering into the merit.
Now, I beg to apologize.
Under Order 9, Rule 13, yes, I can understand simultaneously both appeal and the Order 9 rule, the setting aside the ex parte decree can be. Because of the explanation appended to Order 9, Rule 13. But under Order 9, Rule 8, no explanation. Under Order 9, Rule 9, no explanation.
I respectfully submit the observation of the court. I deeply appreciate.
So you want a simpliciter withdrawal, we can permit it. Straight, unnecessarily
No, I'm
going
not going-
academically,
No,
going
no,
academically.
I will take back. Will only,
Take back, take
will
back.
Only one
take back.
point, your lordship, allow me to make a submission. Only one.
Now tell us, where is rupees 20?
Lord, it has been recorded in the order sheet also.
No. Oh, yeah,
It has been
yes.
recorded.
Yes, yes.
Lord, only one point, if you are subject to the leave of the.
Oh,
court.
you have deposited 80?
Yes,
More? Oh, no, yeah, sorry.
the only deficiency is the 20.
Yes.
Only subject to the leave of the.
Unnecessarily, others are waiting for their
I
turn.
get it.
So
Yeah,
it's better,
Only I,
better to go make further research on this. No difficult.
in that event, I humbly beg, liberty may be given to appropriate.
That is always there.
Well, the particular observation. Very well.
The deficit court fee of rupees 20 has been put in. We did document number 2 on 26th February 2024. Office is directed to tag the court fees with the instant memorandum of appeal. The counsel for the appellant submits that the instant appeal has been wrongly filed before this court, and therefore prays for withdrawal thereof. In view of the above, the appeal is dismissed as withdrawn. Let the certified copy of the impugned, let the certified copy annexed with the memorandum of appeal be returned to the advocate and record by the ACO upon replacement with photocopy thereof. The withdrawal of the instant appeal shall not prevent the appellant to pursue the remedy as available in law. This is what I have said. Yes.
Yes. May it please, my lords. Now, this matter had appeared yesterday under the heading for extension of interim orders. Mr. Choyan Gupta was addressing my lords. My lords had,
He is gone.
my lord, he is not here right.
Yes.
He is not here right now. My lord had yesterday opined.
Sensing,
Yes, my lord.
realizing the mind wavelength of the judge's mind.
My lord, he is on legs before another division bench of this honorable court, my lord.
Just thought that sensing that
I bowed.
services have been affected.
Yes, my lord. Yes, sir. The affidavit of service was taken on record.
Okay. This court has moved on. What has happened? In the meantime, the injunction application has been heard.
My lord,
This
every
court-
time whenever we place my lord's order saying that this is the injunction application, and because my lords have not made it absolute, but the court below fails to take into cognizance or
No,
opines.
I can.
Yes,
There is a difference between an ad interim order of injunction
Yes, my lord.
and the temporary injunction.
Yes, my lord.
So far as ad interim order of injunction, I understand he
Yes,
has
my
not extended it, is no longer there. But what about the temporary injunction application? It has to be disposed of finally.
Yes, my lord. But
What he's doing?
the court below, my lord, opines that he no, no, my lord, the hearing on my injunction application has started. However, the court below now opines that since I had obtained an order from my lords, he no longer has power to pass any order on this court.
Sorry?
This
Temporary injunction application.
I appreciate, my lord. That is the peculiar situation that we are in, my lord. That is the conundrum that we are facing. Why we have to come before my lords on this for the second occasion.
Which court?
My lord,
Barasat.
first civil judge,
Senior division, first court, Barasat.
Yes, my lords. Had that not been the situation, my lords, we would not have possibly been before my lords.
It is still there. Who has passed the order of 5th October 2023?
Yes,
It is
my
still
lords.
there.
Yes, my lords.
Execution of that in compliance with the certain order passed by the court. The petitioner has made all compliance. The excess circumstances unless the interim order is further extended till the disposal. For this, till such time the court may take suffering. Therefore, break the extension of order granted by this court. I have perused the order of the High Court in such and such. On perusal of the several appear to pass the interim order of such and such. Further pass the order of such and such. Court holds that the said interim orders are continued. So, it what it that will be passed by the trial court in connection with the injunction. But in the meantime, the injunction should not go before this court. Most like there is also not given an action upon this court to extend the second. Can you say that I will not? Yeah. No, he says that connection with injunction may pass by the connection with whichever is earlier. Any order, whichever is earlier. How can he say? Defendants are not appearing. Also. There also are whether the defendants are appearing.
Not yet. They have not appeared yet. We have
Service,
served on
publication, everything has
everything
been
is
done.
done. Every direction that my lords has passed, we have complied with. My lord wishes I can take my lords through each and every single compliance.
It's complied everything. This can't be because the order of justice said. Where is the order of justice said? Last order.
My lord will kindly come. Page 52 is the first order. Page 54 is the second order.
Last order I want.
Page 54, my lord.
Ask the lifted entry order feels that all the documents entry order
We are dated 10th August 2023.
in the meantime. So what is after being satisfied with the service being affected about response. Pass an incident. That was there. Say that if the steps are not taken, then it is open to the court to vacate. So every power is Straining the responsibility to accept any Oh, this is a suit for specific performance
Yes,
of an
my lord.
agreement.
A memorandum of understanding. Yes, my lords.
And the interim order is not to proceed,
Yes, my lords.
not to accept any offer.
Yes, my lords. Because, my lords, I have annexed that they had approached websites where properties are sold and had listed the property on such website for the purpose of sale in violation of the memorandum of understanding. So that was the cause of action of my suit, or one of the causes of action of my suit.
Despite several attempts having made to serve the respondents, there is no appearance on their behalf. The matter is taken up for final disposal. As the scope of the instant appeal appears to us being limited, there is no point in keeping the appeal pending before this court. The instant appeal arises from an order passed by the trial court refusing to extend the ad interim order of injunction passed in connection with the said suit, solely on the ground that the trial court is denuded of power to extend the order passed by the High Court. Full stop. The appellant filed a suit for specific performance of an agreement / MOU for sale of the immovable property and took out an application for temporary injunction, as the respondents have published an advertisement in an official in a website dedicated for the purpose of sale and purchase of the immovable property.
Real estate.
And Therefore, they should be restrained from taking any steps for alienating, transferring, and or selling off the property pending the said suit. The application for temporary injunction was moved for an ex parte ad interim order of injunction, which was refused by the trial court. And assailing the said order, the appellant preferred FMAT 328 of 2023 before this court. While admitting an appeal on 3rd August 2023, this court passed an ad interim order of injunction restraining the respondents to accept any offer in terms of the advertisement mentioned at page 95 of the statement application filed therein. Apart from the same, the division bench of this court also restrained the respondents from alienating and or encumbering the suit premises for a period of 2 weeks from date or until further order, whichever is that. Full stop. After the service was attempted, the matter appeared on 10th August 2023. And the division bench was satisfied that the respondents are avoiding the service and dispose of the said appeal by extending the operation of the interim order passed on 3rd August 2023 by 8 weeks from date, or with the rider that it would be open to the trial court to pass any order any order in connection with the injunction application, whichever is earlier. Apart from the same, the court also directed the appellant to comply certain directions relating to the service to be effected upon the respondents, which according to the appellant has been religiously followed with. Since the application for injunction could not be disposed of within the extended period of ad interim order of injunction, an application for extension of the said interim order was taken out, which is rejected by the trial court on the ground as indicated herein above. Without venturing to go deep into the aforesaid aspect, we hasten to add that the court was conscious that the division bench was conscious at the time of extending the ad interim order of injunction that the application for temporary injunction would be disposed of within such time. However, the division bench gave liberty to the trial court to pass any order as the circumstances so warrant, which cannot be construed that the trial court is denuded of any power to extend the ad interim order of injunction. Even the division bench bestowed power upon the trial court to vacate the interim order in the event the compliance as directed therein has not been made by the appellate. Full stop. Considering the tenet of the aforesaid order, we do not find that there is any difficulty on the part of the trial court to extend the ad interim order of injunction upon recording reasons to stop. If the trial court is conferred with the power to vacate the ad interim order of injunction passed by the division bench of this court, we do not find any reasonable logic into the mind of the learned judge that it cannot extend such interim order in the event the application for temporary injunction could not be disposed of within the period of its operation. At the time of admitting the instant appeal, we reimpose the interim order, which is continuing till date. In view of the findings made herein above, we do not find that the manner in which the trial court rejected the application for extension of interim order is proper and legally sustainable. The order impugned is thus set aside. The trial court is directed to dispose of the application for temporary injunction within 4 weeks from the date of the communication of this order, provided the trial court is satisfied on the service having effected upon the respondent in terms of the order passed by the earlier division bench. Stop. The interim order granted by this court on 11th October 2023 shall continue till the disposal of the application for temporary injunction or until further order as may be passed by the trial court. Appeal and applications are disposed of.
Extremely obliged. My lords, kindly.
I am appealing for the appellate. এই ডকুমেন্ট তোর কাছে ডকুমেন্ট দিয়েছে
What is this appeal?
This is regarding vacating the order of injunction in suit for partition.
What was the nature of injunction?
Not to change the nature and character, and parties are directed to maintain status quo in relation to the possession of the property. They filed an application for modification or variation of the order of injunction on the ground that they are making construction in a specified portion basis of the aid given under the specific scheme, there is Pradhan Mantri Awas Yojana, and allowed them to complete the construction. Our contention was that the scheme under which they are asking for the construction is that is a particular specific portion is there because under the said scheme, it is demarcation or the nature of the building, all have been declared under the scheme itself. So construction cannot be made more than that. But from the nature of construction, it appears it is not the scheme, but they're making a huge construction over the property. The trial court is granted permission to complete the construction without indicating what is the position he is occupying, the extent of construction they want to make, nothing to that aspect. On the contrary, the court is of the opinion they are in specific demarcated portion, so they should be allowed to make construction. This is sum and substance, my lord. Basis of which, my lord, I am before your lordship. My lord, if your lordship can turn to the application for injunction.
Yes.
Application. Now I can turn to application which have been filed when the application was stay. The application for injunction has been annexed. Their vacating application has been annexed.
What is the stage of construction?
Initially, my lord, these are photographs. Initially, when I filed the suit, that is at the initial level. Subsequently, my lord, now, my lord, in passage of time, the construction must be. But whether I am inviting my lord to decide whether this type of construction can be considered to be a construction made under the scheme itself.
That is the matter between a government where they have been provided this particular.
Yes, for the purpose of.
That is what is it is the matter of between the government because they have given them money.
So this is not can you consider the money is given for the making a particular type of construction.
If there
Not
is
only that, my lord,
any misuse of that money, then it is the government who will take an action.
that scheme cannot be that on that ground. It cannot be said that I am in such a position I cannot maintain a construction without the aid.
Can you put the clock back now? Suppose the government decided to take back the money. The construction has come up. They have to give back the money to the government. The only thing is that if the construction has already been made in respect of a larger property, then in that event, at the time of final decree, no equity can be claimed by them.
Well, can you pause there for a moment? I am arguing on this point whether the public money can be
trial versus some share.
Yes, my lord. Kindly consider whether the public money, it is the involvement of public money.
Again, I am saying you are correct. They look at it. It's a public money under a Awas Yojana, whatever. They have been given a money which provides that you can construct one room, two room, 3 room,
300 square feet under the
whatever, 50 square feet, 6 rooms.
300 square feet.
Oh, 50 square feet, at least how much it will come to? 300 square feet, 50 square feet room, 6.
Specific map is also there. They are also providing the map also.
You don't know how many rooms they will create.
Yes, because 300 square feet is the total constructed area.
Correct.
Under the said scheme.
Now they have constructed 500 square feet, 5,000 square feet.
Pause there for a moment, my lord.
I'm no. 5,000 square feet. You pause for a moment. Suppose they have done. So, what is there is that under this Awas Yojana, where certain category of persons are entitled to avail that particular benefits or incentives. If they have the resources or the money, I do not know. What is that? What are the criteria? I am not aware of that. Suppose if the criteria are not complied or met by him, something he has suppressed, then it is definitely a matter of great concern, is a serious concern. Then the authority must activate their process and take action against him. In a civil suit, in a suit for partition. Now, question is, at that point of time, source of money they disclosed. They are not supposed to disclose the source of money. Let us go in this way. They have the means to construct.
No, they have.
Can you? I am just asking if the substantial construction has come. Can you now say you crumbled it down? You just demolish it, bring it.
And kindly consider, I filed an application on the basis that I got that sanction and on basis of which I want to complete my construction. So construction is based on the fact that under the specific scheme I got.
It is, that's why I'm saying
So
under the
today, my Lord Kalika, on basis of which the order was passed, the injunction was vacated.
question is, sir, at this stage, if we accept your version, that means the action which the authorities are supposed to take under a particular law governing the field, we are usurping that power. We are exercising. We are doing whatever you want here and now. Can the court substitute itself into the shoes of the authority?
So far,
unless there is a glaring illegality, I can understand.
Well, this is a circular for the purpose of construction of the said scheme. My Lord, I am on the fact, my Lord, I came before the court with a prayer for variation of the order of injunction that I got the money, I want to make construction. Subsequently, if it appears, my Lord, that is not the ground. So I asked the court to pass an order on the basis of his assertion that this is the money. If the money is gone away, then I am not in a position to complete the construction. On this ground, this injunction has been vacated from the order impugn, my Lord, I will satisfy your lordship. That is the ground. And if the court does not come to a finding, to what extent?
Not know the nature of the scheme, what is provided in the scheme, what is said.
Yes. If your lordship can consider,
we don't know. We are not aware of
only the total floor area ratio.
That is not. What is the purpose, object? What is that? We have to go into that.
Then one thing, my Lord, they are now in occupation. They are making construction on the basis of that vacating of the order of injunction. Today, my Lord, the basic thing. EWS house, next page at the top. 300 square meter, 30 square meter.
Correct. Yes.
Now, my Lord, kindly consider the application itself. So, therefore, my Lord, this is the economic weakest section. 30 square meter is the construction.
The sections. They are also entitled. From schedule granted from the back. So
Now, my lord, kindly consider I am only drawing lot. What is the application? What is the amendment made?
no, tell us from there what you want to drive at.
That 30 square meter is the extent of construction. Yes, my lord, subject to question, my lord.
Please read.
All well unit multi having carpet area up to 30 square meter, which adequate basic civic service.
This is kindly visualize. We have gone through the schemes. A scheme does not say only 30. A scheme says even an existing.
Is up.
There, even an existing. Then, if you want to expand, you can expand up to 30 more square feet of area. But again, it says that it is not a rigid one because it is a flexible one. All depends upon the situations. Here, they have categorized not only the economic weaker section, having an income of 3 lakhs rupees per month or less, but they have included the middle income group person also between 3 lakhs to 6 lakhs.
They will provide the loan.
High income group persons for the purpose of availing the loan under this particular scheme.
So far in Bengal, my lord,
They
only
can
the
go.
first portion has been implemented.
Again, I'm
The
saying
first
what
portion
they
has
have done,
been
they have constructed beyond 30 square meter. That is up to them, but they will not be required to get money beyond this.
Yes. Now, my lord, that is why, apropos to this, my lord, what is the amendment made in the application for variation? My lord, may I read out?
If some, I think we are live.
It is their case that I want to complete that construction which I get pursuant to this scheme. It is not a case that I have started a construction and I also having subsidy for making a portion of the construction. I want to make construction. It is a specific amendment made in the application that under the scheme I get that money and I want to complete that construction. And what is the exact occupation? What is the area? Nothing is there.
Structure has come up, complete.
Yeah, more or less কত দূর হয়েছে দেখ না তোর কাছে আছে তো কোনো ছবি So therefore, the injunction order vacated. Procedural lordship any action admitted the appeal and directed the appeal be heard. So in the meantime, they may be going on construction. Can you consider the amendment based on which the injunction was vacated? If it found that the amendment is not correct, whether for that reason, my injunction has been vacated. Injunction passed in my favor was vacated. And the learned trial could not even gone through what is the extent of construction, what is the area in occupation, nothing to that extent.
What is the stage of you have filed your written statement?
No,
That the impugned order records everything. That the conduct of Mr. Roy's client.
Very
He
bad.
is a very jealous co-sharer. He has 2 decimal share in respect of that plot. I have 16 decimal. Initially, the father, my learned senior friend's client's father, filed a suit for partition. There, this plot is being included over there. In that suit, he secured an order of injunction in respect of procedural property, where this plot was not included. At the time of giving the final order of injunction, the learned trial judge mistakenly have included in respect of the entire suit property. So when I got this scheme to be availed, I started construction, he said, no, you can't do that. I filed a writ petition on the impression the injunction order is restricted to This honorable court for the first time they show no. The final order of injunction included the entire suit property, so you cannot construct. This honorable court, after showing the order, this honorable court give me liberty so that I can vary the order before the Lamed trial court in that suit. I gone there. Applied for variation. That suit, the injunction order has been varied.
Show us the plaint and the co-schedule.
Yes, may I just say, everything is on record. He has annexed. Now, my lord, I varied in that suit. The learned trial judge, after showing that yes, it has been done mistakenly, varied the injunction order, left that suit property free. I started construction. 17 days thereafter, what happened? The father transferred that 2 decimal to son, the present plaintiff. Another partition suit. In this partition suit, again an ad interim order.
There they included yours.
Yes. Again, Milord included this, Milord. For 2 decimal. The transfer has been taken place by father to son.
No.
Son filed a partition suit.
But in this son suit, they included your property.
yes.
This was excluded there.
Yes.
Co-schedule did not contain your property.
Yes.
So this is what is there. Then
Milord, this ad interim, I again, Milord, have to approach the court by filing and vacating application. After the conduct is being shown, and I have also shown, Milord, the specific demarcated portion is being transferred. I am not on that. So after this conduct, that yes, father was litigating all along, he has taken advantage.
what has happened to that suit?
That suit is still pending. That partition suit, the second partition suit,
They have been substituted. Are they pursuing? No.
In that partition suit, yes, Milord, his father is pursuing.
His father is?
Yes.
He's alive.
Yes.
Oh.
His father is alive. He will have taken a call to file a partition suit where this plot was being included. He obtained an order of injunction excluding this plot.
দেখেন বাকি প্রসেস
Gift or sale?
That
gift.
And Milord, Mr. Roy is pointing out, Milord, regarding the 30 square meter, as your lordship has rightly pointed out, this scheme is not restricted to that class. Here, Milord, 30 square meter is up to the administrative panchayat rules, Milord, where no permission even necessary. It is not my case. I have annexed everything. I have mutated my name. Thereafter, conversion was being made. Thereafter, I applied for sanction. The Milord, panchayat authority granted sanction. Only the financial aid up to that Milord limit is being availed of. It's my case all along that I have annexed everything. Lord, that was before the court below. My certificate, Lord, Gram Panchayat Pradhan permission to make construction, everything is there. Lord, conversion certificate. But it is only, Lord, my co-sharer who has 2 decimals of land, he doesn't want. And I say, without claiming any equity, and your lordship knows subsequently, Lord, the Israel versus Samson is being diluted by this honorable court. But I'm carrying that judgment.
There was already an existing structure.
No.
It
Phase
was
structure.
barren land. It was a barren or a vacant land.
Barren land. Vacant
After
land.
conversion, after Lord, the sanction plan, I started making construction.
It was an agricultural land.
Yes, initially it was.
And now it has become converted into a homestead.
Homestead. Homestead. Bast.
They did not challenge that conversion.
We did not know.
When
because it
Lord,
was
my
not-
pillars come up, then Lord, they shown the first injunction order, which I got vacated. Thereafter, the gift and Lord, the second suit, second injunction order. Again, Lord, I will have to file Lord, application for vacating, and ultimately by the order impugned, that has been vacated. And since your lordship has, at the time of admission of appeal, didn't Lord granted any stay, Lord, my client pursued Lord and started making construction. And now the construction is almost complete. Now the window and doors and the Lord shutter gates have to be Lord fixed. Nothing else. And Lord, 16 decimals I do have. He has 2 decimals. I said I will not claim any equity. Even if his second partition suit is not maintainable. His father is pursuing first suit till date. And Lord, very interestingly, just 15 years. Judgment. Choice name.
Yes.
Not very interestingly, when the father
Facts are very ugly.
So the facts, if your lordship and my lord kindly call.
Your father, he instituted a suit for partition, asked for an injunction. The injunction was restricted to co-schedule property, which does not include his property. Co-schedule is beyond
Both the schedules are there.
Yes, but it was restricted. Ad interim order was up to co.
Paid for.
Land, whatever the co. Then ultimately, at the time of disposal of the temporary injunction application, it was extended to whole. Now they challenged this. They were given a liberty to ask for vacating. They filed. After looking everything, the court vacated that interim order. Now you, after acquiring title from your father on the basis of the deed of gift, filed another title suit. 2 title suits are simultaneously being pursued. I am aware of the devolution of interest concept. Father can, but any order that would be passed will be binding on you as a transferee. Pendentility. There for that suit.
Yes.
Not for this suit. That suit you are a transferee pendentility. Now you file a suit on your own title. That by virtue of a deed of gift, I have acquired the right of my father. And then, same thing you have started. Whether at the time of passing an injunction or vacating, the conduct is also one of the very relevant factor where the court will look into it. What is your conduct? What is your conduct? You have your house in 2 decimal.
It is initially vacant land. It is
I do not know. You have a house in 2 decimal?
in a separate plot, he has a house.
Not. This is an entire
Plot
chunk
is
of
not
plot.
having got other plots. also.
What he has done is entire front portion has been
Not
constructed.
need to utilize my property.
What is my property, my lord? It is a co-share property. He is also a co-sharer.
Sir, he has really improved the value of the property by making a conversion from a agricultural to a homestead.
Now, rest of the
So-
he will not exploit it commercially. He will enjoy the property, and
He will enjoy what? Partition, when the partition decree, final decree, the court will say how much share you have in the larger property. That the court has to determine at the time of preliminary decree. And then what portion should be allotted to you has to be considered.
existing possession.
Existing possession, he says, I am not going to claim equity, but he will definitely claim the position in respect of that portion, not a structure, because at the time of determining the royalty, they may not take into account the expenditure which he spent, expenditure for a construction, but at least he or the plot of land, he's all along asserting that I am in possession of that portion. Can he not?
No, he's
Can he
based on the
not?
fact. So, based on the fact that one of the
That is
portion
the
transferred a
different issue.
divided
The
portion.
court will consider this is an admitted position that your father sued, the injunction was vacated.
Yes, that is there.
So we will record this and we will again make a lot of observations. Your conduct is such. No, we'll make observations. I think where is that judgment of the Supreme Court which says the conduct is also one of the very important factor in determining the injunction applicable. আছে এখানে?
আজ বার করার কি আছে? খাতাপত্র নিয়ে এসে বার করে দেন।
Let me bring out those judgment. Bring out that judgment.
These are the all what is flown from
No, earlier there is a
Earlier-
1990 or so judgments are there. Yes.
এই জাজমেন্টটা দেখিয়েছিল ঠিক আছে এটা দেখি
The instant appeal arises from an order whereby and whereunder an application and order 39 rule 4 of the Code of Procedure filed by the defendant respond. Defendant number?
কি বললেন কি চাইলেন ডক্টর
You are a defendant number?
Yes, my lord.
Tell us here as a respondent, tell us.
Here, my lord, respondent number one.
one
Filed by the respondent number 1 is allowed on contest with the permission to complete the construction at suit plot number 2157 without claiming any equity.
Defendant number one. My lord, the defendant number one as well, my lord. The defendant number one in the trial.
Yeah, respondent number claiming any equity. Simultaneously, the trial court also modified the order of injunction granted on 12th July 2022 to the extent that the both parties shall maintain the status quo in respect of the possession of co-scheduled property. Full stop. The appellant, now admittedly, the appellant filed a suit for partition and separation of shares, alleging that the property described in the schedule is a joint property and the parties are the co-sharers / co-owners thereof. The right, title and interest is claimed by the appellant on the strength of a deed of gift executed by his father, which according to the respondent number one is restricted to 2 decimal of land, whereas the said respondent number one has a 16 decimal of land in respect of a larger property. Interestingly, the father of the appellant instituted earlier suit for partition and separation of share being title suit
number 41 of 2012.
41 of 2012. And sought for a temporary injunction in the similar fashion as has been sought in the instant suit. In the earlier suit filed by the father of the appellant, ad interim order of injunction was granted in respect of a co-scheduled property, which according to the respondent does not include the portion of the land enjoyed, occupied, possessed by the respondent number one. However, at the time of disposal of the application for temporary injunction, the said ad interim order of injunction was extended to the entire property, which constrained the respondent number one to move appeal under Order 43, Rule 1 within brackets small r.
Not in appeal. I filed an application under Article 226, saying that inaction on the part of the police why he is interfered.
Full stop. Which constraint কেটে দাও. Subsequently, an application for vacating the said interim order, application for vacation, variation and or modification of the said order was taken out by the respondent number one therein, and the court thereafter allowed the said application, meaning thereby the order of temporary injunction was not extended to the portion of the land claimed by the respondent number one. Amidst the pendency of the said suit, the father of the appellant executed a deed of gift in favor of the appellant, and on the strength of the right, title and interest acquired as donee, the present suit is filed
19 days after.
Present suit is filed for partition and separation of shares. Obviously, the application for temporary injunction was disposed of, restraining directing the parties to maintain status quo in respect of the entire property, which includes the portion occupied, possessed, and enjoyed by the by the respondent number 1. Stop. Subsequently, an application for variation and vacation and or modification of the order of temporary injunction was taken out, taking a multiple grounds, including that the construction which has been ensued by the respondent number 1 is also taking benefit of the scheme floated by the central government known as what?
Pradhan Mantri Awas Yojana.
Pradhan Mantri Awas Yojana. It was contended in the said application for modification and variation of the said order that if the order of status quo is not varied and or modified, the benefit under the said scheme shall be lost. The trial court, after taking note of all the antecedents in respect of the scheduled property, modified the interim order to the extent as indicated here in above, and permitted the petitioner to complete the construction. Though the instant appeal was admitted, but there was no order of stay granted by this court, and it is undeniable that the construction has seen the substantial progress, and according to the respondent number 1 is virtually at the fag end of its completion. Without going into the nuances of the provisions contained in Order 39, Rule 4 of the Coordination Procedure, whether the respondent number 1 has been able to make out a case envisaged therein, we feel that the conduct of the parties in relation to the litigation should also be taken into account. And there is no fetter on the part of the court exercising equitable jurisdiction to take such aspect into consideration. The father of the petitioner, who had the right title and interest in respect of a share held in the undivided property, could not succeed in getting the injunction in respect of the portion claimed by the respondent number 1, and clandestinely gifted the said property to the present appellant, being the son, which augments the institution of the instant suit, claiming the similar and identical reliefs and more comprehensive injunction against the respondent. Stop. At the very outset, we must record that the court should be slow and circumspect in granting an order of status quo, more particularly when the position is highly disputed. The court, while embarking its journey in passing the order of status quo to be maintained in respect of a property, must specify the respective position of the parties, as such order, being ambiguous in nature, is susceptible to be misused in the hands of an unscrupulous litigant. Furthermore, a co-sharer have every right in respect of every part, be it minuscule or otherwise, over the entire undivided property, and their respective positions is deemed to be a position on the strength of such undivided share, as well as on behalf of the other co-owners / co-sharers, unless any of the co-sharer claims exclusion of the others. Undeniably, full stop. Undeniably, the present appellant derived title on the strength of the deed of gift executed by his father, who is still pursuing his remedy of partition and separation of shares in an earlier in an earlier instituted suit. The multiplicity of the suit is evident, and the motive and the motive is laudable. The court exercises the equitable jurisdiction in considering an application for temporary injunction as an order pending the final adjudication in the suit is to protect the interests of the parties and the property being the subject matter thereof. The fact remains that the father through whom the present appellant derived title on the strength of a deed of gift could not succeed in securing the order of injunction in respect of a portion occupied and enjoyed by the respondent number 1, comma, it is an apparent attempt on the part of the apparent attempt on the part of the present appellant to thwart the order of injunctions passed in a suit filed by his father. And an attempt to unjust enrichment upon the rights of the co-sharer. Though it is sought to be contended before us that the aforesaid scheme contemplates certain eligibility criteria and the extent of construction to be made they are under. But we do not find that there is any absolute embargo created therein. Even apart, full stop, even apart, it is open to the appellant to take an appropriate steps before the authority is concerned, and ventilate their grievance as we feel that the same cannot be a ground to set aside the impugned order passed in exercise of the discretion vested upon the court and on the sound principles of law. We thus do not find any infirmity and or illegality in the impugned order. The appeal is thus dismissed. No cause. Take back.
Lordship, I am for the appellant, Lordship.
What is this?
Lordship, the plaintiff is the appellant before your Lordship, judgment of reversal. Lordship, I am the mother, and Lordship, the respondent is my son.
Your suit was decreed and then
Reverse, Lordship, suit for eviction of a licensee, Lordship.
by mother against
Son. Now, Lordship, your Lordship's heard out this matter, Lordship. Here what happened, Lordship, the mother.
Anybody is appearing.
No, Lordship.
It's better to go for a mediation and then get it. These are, look at, the relationship is very, very,
True,
very
Lordship.
sweet in my personal view.
Lordship.
Son and a mother, what more? More secured, I would say, a person feels in the lap of the mother.
True, Lordship.
Why mother has gone? Why you
But
want
Lordship,
your
he is
son?
torturing. That is why, Lordship, she was forced to file this suit for eviction, Lordship.
What he does?
Lordship is an auto driver.
Yeah.
An auto rickshaw driver.
What you were doing? What you used to do? You have purchased the property or you built the property
Yes, Lordship. It was granted by the government of West Bengal, Lordship.
under the
Refugee rehabilitation. Yes.
But the scheme is such that it is
But
for
Lordship,
the purpose of
on the
entire
last occasion,
family.
I placed the circular, Lordship.
Was he born at that point of time when this was given?
When this gift was made?
No, when this rehabilitation, yes.
Yes, he was born. He was a minor at that time.
So
Lordship, on the last occasion, Lordship, I handed over the circular, Lordship. Lordship will kindly come to the circular, Lordship. I don't have the circular, but it was set out, Lordship, in an unreported judgment. Lordships will kindly come to page 5. in a page 5 of the unreported judgment, Lordship. That circular has been set out there, Lordship. And at page 6, Lordships will kindly take up clause 2, Lordship. It says, Lordship, the undersigned is therefore directed to say that the conveyance deeds, leasehold or freehold, as may be approved from time to time, which have not yet been executed, shall have to be executed by all the persons who were shown as comprising the family, his legal heirs, if anywhere was dead, if the actual allotment order was not issued in favor of a common propositors, or if there was not common propositor among the person whose name were recorded in the allotment register as comprising the family. So, Lordship, after this circular, Lordship, initially a lease deed was executed in favor of my client. At that time, her husband was also alive. Thereafter, Lordship, she surrendered the lease, and Lordship, a deed of gift was executed.
Freehold now.
Yes, and Lordship has seen, Lordship, the clauses of the gift
Now,
deed
family,
also.
we do not know because the register is one of the very important thing at the time of allotment or at the time of giving a property in lease. The authority must have maintained a register that who are the constituents of the family.
Lordship.
Because this clause 2 also talks about that.
Yes, Lordship.
So we wanted to look at it, whether he is taken as a member of the family at that point of time, recorded as.
Lordship, no
that.
such document was produced before both the courts below.
Absolutely, that. Thinking of-
Your Lordships wanted to see this act, Lordship.
No, this is the subsequent freehold. These was the first. And she's the mother.
No, the grant, was it in the favor of a prepositor or
Lordship.
several names were recorded?
Only, Lordship, the name of the mother.
The propositor, but for the purpose of family is to be maintained because clause 2 says so. You have to be executed by all the persons who are shown as a comprising the country. If the actual allotment is not issued in favor of a common propositor, or if there was no common propositor among the as comprising the but never mind. It is has to be for the benefit.
Not only this, Lordship, even in the cross-examination also, Lordship.
Is it that particular no doubt. He's a senior. There's a together, sort of. How many sons you have?
4.
All are residing there.
No, all are not residing with me. All are not residing with me.
What they are doing? Others?
That I have to take instruction.
He is the only person who resides, or there is another person, another son who is.
Another son is also residing, Lordship.
Any caveat is lost.
No, Lordship. There is no application also. There is no application. And we have not received any copy of caveat. If your Lordship so desire, I can serve the copy of the memorandum.
I was thinking of, yes, I was just thinking of the mediation for that purpose, because after all, the relation is very.
True, Lordship. If your Lordship so desire, I can serve a copy of the memorandum, Lordship.
Considering the nature of the dispute and the relation between the parties, considering the nature of the dispute and the relations between the parties, we feel that admission of an appeal may not subserve the justice at this stage, as the parties may be able to resolve their disputes if the process of mediation is activated. In such view of the matter, we are not formally recording the admission of an appeal, but direct the appellant to serve the copy of the memorandum of appeal to the respondent, upon the respondent. In the covering letter shall indicate that this matter would again come up for admission on today we are on 11th March.
Lordship, on that day, may both the parties be also personally present, Lordship.
Why?
Then your Lordship can talk with the parties directly, Lordship.
We expect that what is the age of your client?
She's quite aged, Lordship.
Then madam. We appreciate, but if she's aged, then we should not compel her to come. Ensure if you can.
Lordship.
That is up to you.
Respectfully.
My lord, in item 20, learned advocate on record informed me that her father has been hospitalized. My lord, can we get a time of 1 week? Grateful, my lord.
1 week. Adjourn for a week.
I did to appear on behalf of sir. That's not that. Lord, I appear not on behalf of the appellant. It's a suit, my lord, under section 22 of the Hindu Succession Act. But my lord, this
New Succession Act.
Hindu Succession Act. Hindu Succession Act.
I heard New Succession Act. I was surprised with that.
No, my lord, section 22 of the Hindu Succession Act, but my lord, the stamp
Preferential right.
Preferential right. The stamp reporter, my lord, reported
7,760 rupees. 100 rupees. Second appeal. Believable. When
anytime, my lord, your lordship. Client has to
seen the report of the stamp reporter indicating that the instant appeal has been filed with a deficit court fees of rupees 7760. Time to put in the deficit court fee is extended by a week from date. List the matter on next Monday is
next Monday
4th.
Great.
My lord, advocate and record has requested me to pray for time because he's busy with the court number 29 for anti-security bill matters.
Those are very important.
No, my question is that
that involves a fundamental right of personal liberty under Article 21 that we have to consider.
Possible maybe.
And these are all civil rights Nothing.
Just he made a request to me, that's why I
It is more paramount than this. True.
Since I am appearing for 23, that's why he requested me to pray for time or not today.
He's very busy there. He has to take care of that. Anyhow. Next.
23. I'm the petitioner in this case. That's it.
My lord, I'm for the respondent husband. I'll take leave to appear online.
What is this?
It was the case that Order 9, Rule 13 was
second appeal in a matrimonial proceedings.
Yes, because the division.
What? How?
My lord,
It's FMET.
FMET.
Item number 23. Sorry.
23.
Why FMET, sir?
Because my Order 9, Rule 13 was
Dismissed
by the lower courts because there is a delay of 82 days, and I submitted the reasons for what.
Yes. A live streaming is paused.
yes, my lord, I cannot see, my lord.
No. When a live streaming is paused or not? Paused.
My lord, in the last two occasions,
What is the ground for divorce? What is the ground for divorce?
they have stated that is a cruelty and desertion, but that is not the fact. That is my matter of challenge on this case. Rather, it is the first case. They have oppressed me like anything, and that's why I had to leave the matrimonial house and staying with my mother. And they arranged, and it's good that as per the suggestions, they arranged a meeting only on occasions. Both parties were present there, but no outcome. Final result came out. They tried to contact the husband. What she told me on the other day, that we are trying to contact him, but
she is unable to contact.
My lord,
with that Ankit Agarwal, I think is a
my lord, I am appearing for the husband, my lord.
Madam, you are not audible.
No, it is
my lord, I am appearing for the husband, my lord.
Yes. Yes.
My lord, on the previous date, my lord, for settlement, my lord had directed, my lord, the parties had sat together, my lord. My lord, certain terms were proposed. My lord, my client is still it is requested for some time to see whether those terms are viable, my lord. My lord, I'm praying for a accommodation for 2 weeks, my lord, in case if that can be worked out, my lord.
So I'm suffering because she's trying.
My lord, it involves substantial my lord, obligations, my lord, just 2 weeks time, my lord, to figure out if we can provide them. Otherwise, my lord, we will go ahead with them.
We appreciate what you say. So let us pass the order.
Yes, my lord.
As the counsel for the respondent submits that the parties, in fact, are exploring the possibility of an amicable solutions. And according to her, there is a strong possibility as she could perceive the ray of hope in this regard. She prayed for an accommodation for 2 weeks so the parties may ponder upon the terms exchanged between them. So in such view of the matter, let this matter be listed after 2 weeks.
Miller 25 is the same related to the same issue. 23 and
why?
My lord, item number 25, my lord. My lord, I humbly requesting, my lord, let a copy be served upon me. My lord, I'm told that I was by my learned senior friend that.
Please, when your brethren fraternity is wanting a copy, sir.
No. Today itself, I'm having this copy. I'll serve it today. Today I will serve it.
I'm grateful, my lord.
Much obliged.
এটা ওকে ফেরত আসে এসছে But my lord, I have challenged the order, my lord, wherein
Madam, log off. লগ আউট ওটা লগ আউট করে দাও। Yes.
now time for the plaintiff appellant over here, my lord. My lord,
Shoot for partition.
Shoot for partition, initial.
Both.
My lord.
Dismissed by both the courts.
No. My lord, here, my lord, my order.
Oh, FMA. What
order
is
13, rule 1 and 2 was, my lord, stay was granted, my lord, in the form of
Order?
status quo. Order 13, rule 1 and 2 was moved, my lord, status quo was granted on 3rd February 2022. My lord, now, my lord.
Status quo with regard to?
Now, my lord, the
status quo with regard to?
Oh, with regard to, my lord, to keep the suit land in a position as it is on this day.
Okay.
My lord, now, my lord, the impugned order, if your lordship kindly come to the impugned order, my lord.
Rejected the application.
Yes.
Rejected the temporary injunction application. On what ground?
My lord, kindly come to order date, order number 19, dated 6 July 2020.
What the trial court
my lord,
has
the
said?
trial court says, my lord, says non-joinder of parties, and my lord, non-joinder of parties, and my lord, yes, my lord, that was the main ground. My lord, he refuses to
not on merit.
No.
Not
my lord, on extension of injunction was refused on that day. In spite of the fact, my lord, my order 1 rule 10 was pending. My lord, now there was another application for my lord. Order 6 rule 17 and my lord, my order 1 rule 10 2 application was pending before the learned court below. Or even the defendants, my lord, filed their written statement, my lord, beyond the time limit. My lord.
Accepted?
No.
Is this a ground? Suppose you have taken a plea that other co-sharers have not been made party. He has taken out an application for addition of those parties. Is it proper on the part of the court to dismiss the injunction application on that ground? Or the court should have postponed the hearing of the injunction and decide the application for addition?
Now, my lord, with regard to this query, my lord, I am humbly submitting. My lord, the parties that the court has indicated, my lord, by filing order 1 rule 10.
Why it will not?
What I am humbly
And for 1 year, my lord, the injunction was there for the last 1 year.
now, my lord, what I am submitting, my lord, the reasoning of the court for rejecting the application for injunction is twofold ground. For one,
I have not. He has given one ground only. That's why I am thinking.
yes. Now, my lord, another ground, the property, the joint property has not been brought into the common hospital. That is the another ground.
Have you disclosed what are the other properties in your objection?
Who has indicated, my
No. Sir, court is not omnipresent like a god, that who knows what parties are doing and what the parties have done.
Hello?
Have you indicated in your objection that these are the properties which are common and undivided amongst the parties? They have not been included in this. Have you disclosed that?
No objection used.
My lord,
I am asking you, sir.
yes.
How the court will come to know that there are other properties or not? Unless you disclose the details of those properties.
What I am submitting, my lord, the fact of the case, my lord, it is important to indicate the fact of the case. Because, my lord, then, my lord, it will be helpful to come to a, my lord, conclusion. My lord, the fact of the case is that, my lord, my predecessor interest, my lord, Akshay Kumar has made a will. That will, my lord, by allocating two schedule. One is in favor of the my learned friend client and one is in favor of my. Now, my lord, what happened? The will has not been probated. Now, what he has filed this application, my lord, this showed for partition, only, my lord, incorporating my schedule, not the schedule of the, my lord, petition, appellant here. My lord, now, my lord, considering that aspect, the honorable, the learned trial court had come to a conclusion that neither you have made party of the legal heirs of the Akshay Kumar, who was the predecessor interest, and also you have not, my lord, incorporated all the properties that was, my lord, left out in the will into allocation. These are the two findings.
Did you disclose that will in your objection? Did you annex the will in your objection?
Yes, my lord, we have taken this point.
Please, there must be some document forthcoming before the court to arrive at this conclusion. You may say many things at the bar.
In order
I am telling you, suppose the objection says that there are other common properties which are not included in the hodgepodge of this. I did not say that what are other properties. What do you think that the court is supposed to jump to that conclusion? There are other properties. It is your duty to show that these are the properties. That's why I want, there are two ways. Either you could have give a details in your objection that these are the properties which stands in my father's name after his death. Everybody has inherited it. Secondly, you could have annexed the copy of the will where the father has written that these are the properties which belong to him. I can reasonably ascertain or come to a finding that these are the properties which are common. Have you done either of these two? Tell me.
Now, my lord, that effect, my lord, what I am submitting with your lordship. When this order 30 and rule 1-2 petition was heard, the will was exhibited before the trial court, and my lord, all will
Exhibited.
means, my lord,
Exhibited.
It was shown. It was shown on that basis, my lord. This was considered by the trial court.
I am asking whether this will was filed in the record. Was it filed? Was a firisti being given? Whether that contains the signature of the other side or his lawyer, firisti, tell me.
My lord, the firisti was given subsequently after passing this order. It was again returned back to the appellate.
My goodness.
That is the order itself. my lord.
I am simply asking whether there are two ways of relying on a document at the injunction stage in West Bengal.
Exhibit.
The one way is that you have to annex those documents along with your objection or along with your petition. The second way is that you can file all those documents along with the application for injunction through firisti, and the copy thereof must be given to the other side, so that the other side may have the privilege of knowing that what documents you want to rely. Otherwise, the court, because the court is not receiving those documents in evidence for the purpose of marking exhibits,
Yes.
but treating those documents as on record for the purpose of injunction. I wanted that.
Now, my lord, what I am on.
Okay. This is what the system is about.
Now, my lord, the my lord, the
Where is your written objections?
yes, that has been, and that by this by the
Let us see, sir. Where is your written objection? Has he annexed those?
my lord, in the
Yes, yes,
memo he has annexed.
May
No, memo was the certified copy, my lord, as such, my lord, it went.
I am having the copy, my lord.
Nowadays,
must be application.
I'm really surprised.
No,
The
it was a
certified copy
certified
of entire pleadings and all, and those are included in the memorandum. Look at Order 41 Rule 1, what it says, what it should include.
Judgment technique.
Where is your objection, sir? Has it been included in the certified copy?
Mm-hmm.
My lord, kindly and the written statement has been, my lord, accepted.
Yes, your written statement, let us see what you have said.
My lord, kindly consider.
No, it is annexed. Written statement is?
Okay, my lord, the last one.
Just 1 minute, let us see. Have you taken this plea of? Yes, we got the written statement with us.
My lord, kindly consider.
Just 1 minute. Paragraph 6 I am looking at.
There you can look.
Yes, he has taken a specific plea. Now, must have been taken in the objection also. Did you file any reply to that? Did you file any reply?
My reply this is no.
Then what? He has been very categorical in all respect.
No,
In
reply.
paragraph 6, 7 and 8, he has been very categorical.
1 minute. Written objection. না এটা তো অবজেকশনটা এইটার কোনো রিপ্লাই দিয়েছি
How do you have this? In the written objection, you must have taken. If you have not filed reply.
বলছিস এটা তো অবজেকশন
Section 8. Yes, if you have not, then sir.
For once, reduce the order. Every followed the reason has been specifically stated. We will consider all the documents and the objection has been considered by the.
Well, my addition of party was filed, my lord. Well, my order 1 rule 10 application was filed to implement them as a party.
My lord, it was not the left out party. Someone else is trying to implement. Someone else that what has been indicated by the trial court, those are not the parties he is trying to implement. My lord, Akshay Kumar, the original legal, my lord, who has made the will, his legal years has been indicated by the trial court to be impleted. He has not, my lord, taken any kind of, my lord, step to implement them. That's why, my lord, this court has come to a conclusion, this is a defective shoe.
Yes.
My
What
lord,
do you say?
my lord, so far as Akshay is concerned, my lord, his hairs are not traceable.
If they have disclosed.
Or it is in the order itself.
No, they have disclosed. Traceable is a different one, and disclosure of the names are there. So you'll have to implead them as a party, and you know
My
how
lord,
to.
Niranjan was there, my lord. Soranjan was there.
Sorry.
Rajbir was there.
Akshay left behind him surviving how many years?
My lord, Akshay.
2 sons he had, and daughter.
Yes, daughter.
How many?
Yes, so, my lord, different.
2 daughters also.
Niranjan's son, my lord, different
No.
number 1 and 2.
How many daughters?
My lord, 2. 2 sons, my lord.
And?
2 sons.
No daughter.
My lord, 5 daughters.
5 daughters. Their plate has specifically in the plate it has been stated.
So daughters are also required to be impleaded.
Yes.
In the event the will is not probated, then it will be deemed as an interstate succession.
My lord.
So,
And in their malod plane, they have himself.
so
But the
no,
Larnet-
no,
but
this
the
can't be.
Larnet court, my
But
lord.
we will not say that since it is not on merit, on that technicalities, if the technicalities are over, they can definitely come up with the applications. No difficulty. The judicata will not come. Is not no decision on merit.
Yes, malod,
That's all.
yeah.
We'll come back and we'll dictate it. It can't be done.
Come.
Hey, there is one assignment matter. Make a supplementary list for 3 p.m. immediately. Act of notice to be taken up at 3 p.m. Is what to do, sir. We have to just keep
My lord.
your application
My
alive.
lord, for impleading, my lord, the years of Millie. My lord, I have made one application under Order 1 Rule 10. That is pending. And my lord, along with that application, I have filed one application under Order 32 Rule 10 because one of them was, my lord, minor.
Minor, okay.
So I wanted to implement that. Kindly see that application also has been mentioned, my lord, in the impugned order dated 6 July 2023. Without adjudicating those applications, my lord, this order was passed.
That has to be done first.
Now, my lord,
This cannot be done, sir.
now, my lord,
I can understand not extending the interim order, but I cannot appreciate the dismissal of an application for injunction.
And my lord, it was continuing for last 1 year.
now to that effect, my lord, I have
We can't appreciate there are a judgment. There are a judgment to that effect also.
And this is the way
If
they
you
are
look at,
constructing.
my memory goes right, is 1995, AIR 1995 Calcutta or 97 Calcutta. Not in relation to injunction. It was in relation to Order 7 Rule 10. When the plaint was sought to be rejected on a technical ground and an amendment has been taken out so that it should not be disclosed. Our High Court has held, no, you have to first dispose of the amendment application and thereafter you proceed and decide Order 7 Rule 10. Similar analogy if we draw, if there is a technical issues in the suit, then the court ought to have decided that application first. And thereafter, how can he reject the application? Could have kept the application in suspended animation or in abeyance.
He
and
did
then
so.
say that you
No,
will
my lord,
decide
he
this
did so.
application first.
He, my lord, postponed the applications later on, my lord. Kindly come to the order dated 21st August.
I have a
My lord,
specific,
kindly see.
I have a specific submission to that effect.
Kindly come.
What effect?
My lord, why I am saying so, my lord, kindly consider. My lord, he has not taken out application for addition for the
Sir, whatever, sir, under Order 1 Rule 10(2), it is not that the parties has to take out an application. Even a court suo moto can add it. If the court was of the view that these are the co-sharers, why not the court exercises a suo moto power and add them as a defendant? How can it proceed and dismiss? Should have kept it abeyance. I am not going to extend the interim order. I can understand. Dismissal.
He did the reverse. He did the reverse, my lord.
How can it be done?
My lord, the conduct of the appellant is
What will happen? Suppose if they are added, everything is cured. Then again the new application.
My lord,
Why? The affidavits are complete. New application.
and my lord, what I am on, my lord.
Sorry, what?
My lord, kindly consider. My lord, for once, kindly consider.
Fundamental principles of law is really nobody understands.
No, my lord, what has fallen from your lordship from the fundamental principle, my lord, I cannot, my lord, argue on that issue.
So we are simply saying that application for temporary injunction would remain alive, directing these applications to be taken out. The court, if it finds there are other heirs, you have disclosed the name. If they are not, the court can exercise its suo moto power.
My lord, those heirs which have been disclosed by my learned friend, my lord, have been, my lord, we have filed the application for adding them.
We do not know. We are not entering into those arena now.
Their objection says so, man.
So whatever, we do not go entering into, but we say that there is an application seeking addition. That's all. If there are others, the court is not lacking any power. The court can, if the court is satisfied, and thereafter can proceed to decide the injunction application. Even bring any other property which is there in the hotspot. Where is the difficulty?
My lord, what happened, my lord, here the person, my lord, the injunction is a equitable remedy.
Sir, you are a co-sharer.
Yes, yes.
Correct. Don't be a jealous co-sharer.
No, my lord, I am not on that issue.
Now, property is admittedly a joint. You can't say that they don't have a semblance of right, title, and interest. You can't. You have not said so. In that event, why? Suppose if it is dismissed, on a very second day, it's a recurring cause of action so far as the partition suit is concerned. He can institute a suit. On a fresh cause of action, it's a recurring. Every day when he asks for a partition, it gives them a fresh cause of action to file a suit for partition. Unnecessarily, because of this technical objections, the suits are getting delayed. And our experience in this regard is that these partition suits are delayed because of all these things. Years together, the partition suits are pending in the docket of the court. Parties are still fighting to separate their shares.
And taking advantage.
Is this a way
taking
to deal with? No. Substantial justice is paramount.
Yes, my lord. Only my lord.
Where is the order by which the application
order
for
dated
temporary injunction?
6 July
We will not extend it, I tell you.
Yes,
Because as on day that suit is defective, unless all these defects are cured.
Yes, yes.
Yes. Where is the order?
6 July 2023, order number 19.
19.
19.
And my lord, whatever the addition is pending, my lord, that is not the
all
necessary
those
part.
applications, sir, he has not gone into the merit. He has not said
Yes,
that he is not a co-sharer.
No,
Then
I cannot.
even you have not taken a plea that he is not a co-sharer.
And he says, my lord, he says that I have not implemented them as a party. My lord, kindly see the first 3 lines of that orders. My lord, kindly see my order 1 rule 10 to CPC and petition under sections, my lord, 32 rule 10. Now that means I have filed those applications, my lord.
File those applications for some other party.
No,
not
this
the
application for Millie, I've handed
But
over
sir,
the application.
My lord,
Sir, it's not necessary. Have you seen the provision of order 1 rule 10 to?
my lord, court can
Suo motu
himself
pa.
can do
Can
So
I cannot, my lord, join issue
then
to that effect. Only, my lord,
unnecessarily the suit which is pending
yes,
has already matured
and my lord,
after service.
why
These
I
are the
saying
things.
so,
which
my
are-
lord, it shall consider his conduct
देखो,
also.
it is a sordid state of affair that an application for temporary injunction is dismissed by the trial court solely on a technical ground. In a suit for partition and separation of shares,
My lord,
the plaintiff filed an application for temporary injunction and pressed the same before the court for passing an ex parte ad interim order of injunction. It is undeniable that an ad interim order of injunction was passed by this court. And ultimately, after the notices have been served upon the parties to the said suit, the application for temporary injunction was taken up for final hearing. It is a specific stand of the contesting defendants who are represented before us that the suit is not only bad for non-joinder of necessary parties, but is also bad for partial partition. Stop. According to the contesting defendants, several co-sharers who have acquired the right title and interest in respect of a joint property have not been impleaded and or arraigned as defendant in the said suit. And several other properties which are owned and possessed by the heirs of the admitted owner is also not included in the hodgepodge of the schedule. Such being the technical issue and available to a contesting defendants to defeat the suit, which not only appears to be defective in form, but contains a fatal defect, as the decree for partition cannot be passed. The final decree for partition cannot be passed. Now, neither the preliminary decree nor the final decree for partition can be passed in absence of the co-sharers or in respect of some of the properties. Full stop. such defect is amenable to be cured by bringing the co-sharers in the category of the parties to the proceedings, and the left out properties can also be brought within the hodgepodge. In fact, an application seeking addition of party was taken out, but we find the parties are at variance so far as the person sought to be added as a party are do not represent the entire state, for which we feel that the trial court will take care of the same as and when such issues are raised. We do not find any fetter in law upon the court to exercise a suo motu power in striking out the name of any of the parties or adding any parties in a proceedings, provided such parties are a necessary and proper party or unnecessarily have been implemented therein. Actually, it should be reversed. It should be reversed. Anyhow, I will take care of. Undeniably, an application for addition of party and an application
Order 32 rule
for appointment of a guardian to represent the minor are filed by the appellant, which are still pending before the court, before the trial court. The moment the trial court found that all co-sharers are not made party, or all the joint properties have not been included within the schedule appended to the plaint, it is first and foremost duty of the court to decide such application before it embarks its journey on the peripheral of an application for temporary injunction. There is no fetter on the part of the court to give precedence to the applications for addition of party and so that all the co-sharers are brought in the suit and thereafter proceed to decide an application for temporary injunction. The application for temporary injunction may be suspended or kept in suspended animation for a time being until the aforesaid applications pending in the suits are decided. Even if the suit is dismissed on such technical ground, there is no fetter in the law in bringing a fresh suit, as the cause of action for partition is a recurring one. Full stop. It will only encourage the new number and the new year when all the averments made in the pleadings would remain the same. Stop. It will only encourage the delayed justice, and therefore the court must bear in mind that timely justice is the hallmark of dispensation in an adversarial adjudicatory system prevalent in the country. I'm borrowing this expression from a judgment of the Supreme Court in Raptakos Brat versus Ganesh Properties.
If Malot will permit me, Malot.
We thus do not find that the trial court was justified in dismissing an application for temporary injunction, keeping an application for addition pending. We therefore set aside the impugned order and direct the trial court to fix a date for hearing of an application for addition of party, as well as an application for appointment of the guardian to represent the minor. And in the event it is found that some of the co-sharers are not made party, there is no embargo in exercise of suo motu power enshrined under Order 1, Rule 10 within bracket 2 of the Code of Civil Procedure. In the event the objection taken by the contesting defendant is taken care of and the suit is otherwise brought in form, as all the infirmities are cured, the trial court shall proceed to decide an application for temporary injunction on merit.
My lord, can it be done in a time frame manner? Or because, my lord, they are
do it. If they do not,
my lord,
then
they are continuing with the construction, my lord.
My lord,
Kindly
it
see
is-
the, I have given the photographs, my lord.
anyhow, nothing.
At the stage of any defect is there in the foot itself. At that stage, Malot, if any person is coming with a order 30 rule 1-2 application, Malot, our honorable court, this honorable court had passed Malota, which has been considered by the trial court also. In that event, Malota, the order 30 rule 1-2 petition is not maintainable.
Huh?
Yes.
Has it been held by our High Court?
Partition should, Malot.
Our High Court has held. I am not believing that the court will say that the Order 39 Rule 10 1 and 2 is not maintainable.
At that
I
stage.
do not believe.
At that stage,
I do not believe.
Malot, it is my reading. Perhaps I am wrong.
Maybe that you have read a wrong judgment.
Order 30.
You tell me if it is a coordinate bench, we are going to refer the matter to a larger bench. That it is not maintainable, I am unable to accept this. It cannot be granted, I can understand.
Yes.
Because the injunction is in aid of the final review. It can be kept in abeyance for the time being, but I do not approve that it is not maintainable. Show me the judgment. Single bench or a division bench?
Division.
We will refer the matter to a larger bench and saying that this is a wrong proposition. Shows will say so that a person like you should not get so much of encouragement.
No, Malot, perhaps it may be my wrong impression. Malot, if Malot will consider.
Yes.
The first one is Saji Kishku versus Talamoy Kishku, which the trial court has relied.
Cannot be fast.
That is a different issue.
Malot,
Injunction.
It says that you should not pass an order of injunction, which we have also held
Yes,
that
yes.
should not.
Right.
But you are saying not maintainable. I was really shocked with this.
Here order was passed.
It says that it is a settled principle of law that an order of injunction, like all interim orders, is passed only in aid of the final order. I have also
My lord
dictated
said-
it. Then say that an order of injunction is that may be passed in a suit. But whereas here the suit itself is not maintainable, the court shall restrain itself from passing any interim order.
yes, Malot.
It does not say that the maintainability. What are you talking about?
Malot,
We will not exercise a discretion in passing an interim order.
Malot has also done smart.
That's correct your reading of the judgment and correct what you perceived therefrom.
And at that stage, Malot, with that Malot defect, Malot, the court should should not pass the.
I have removed it before.
That
Civil law is not as simple. Civil law is
I
not
removed the
simple.
defect. In spite of that, my injunction application was. ठीक है, अच्छा। Deeply applied.
Yes. Cannot be made. Permissibility of granting an injunction is nothing which cannot be maintained unless what partition granted.
They are in aid of the final order that is there, Malord, I cannot.
Read the judgment between the lines. Please read very carefully. Don't utter a word which is not there. I was really shocked and surprised when you say so.
I tried to say that, Malord, that
No, injunction, whether to be granted or not, this principle has not originated for the first time.
yes,
Even Justice Chittatos Mukherjee in his judgment has already indicated that there are a fourth principles in deciding an application for temporary injunction. Three is well known to everybody. What principle is maintainability of the suit? Anyhow, yes. Yes, sir. Which matter? Sorry. Yes, there was some exchange of words.
Sorry.
Only to correct the young member of the bar, nothing more than that.
But he fought well. He fought well.
True, no doubt.
Unsuccessfully.
No, successfully. At least the interim order of injunction was not granted by. That is his favor.
Akash.
Yes. What is the matter? Who are you? First tell me. Defendant or a plaintiff in a suit?
No, my lord. I was one of the defendants.
Defendants.
Yes. One of the defects.
Judgment of affirmance or reversal?
No, in both the courts we lost.
Yes.
Lost.
What is the nature of the decree?
My lord, the defects in names of the defendant number 3, 4, and 8.
What is the nature of the decree?
The decree is, my lord, that we have to give immediate possession to the plaintiff.
That's a decree for eviction.
Yes.
Against the tenant or against
a specific performance.
That has been
And
allowed.
the plaintiff's claim is that the property in question that belonged to the original owner who made a deed of gift, who made a deed of will. The will was in possession. Now it was the person to whom the will was given, that is the son. It is not the son, but the son's wife gave the particular shop as a tenant to the plaintiff.
I could not gather. Really speaking, I could not.
The original owner made a will, giving the property to the son during his life.
The son is a sole beneficiary.
Son was alive.
No. Son is a sole beneficiary under the will.
Yes.
Son is the sole beneficiary under the will.
Yes.
Who was an executor or executrix appointed?
The son is himself.
Himself.
Yes.
So he's an executor and sole beneficiary.
Yes.
Will was probated.
There was a probate application pending.
Correct.
During the application pending, my lord, it is the wife of that son.
Wife of the son. Yes.
Wife of the son. She gave the premises to the plaintiff as a tenant.
Plaintiff is?
Plaintiff.
Plaintiff is who? Son?
No.
Then?
Another person, the plaintiff.
Third person.
That person.
Correct.
Bhagna. Anyway, the plaintiff was, it was given by the wife of the person to whom
The father gave the property to his will, and during the pendency of the probate, my lord, it is the wife of the son. She gave the property to the plaintiff as a tenant, premises tenant. In the plaintiff's case, the plaintiff's case was that I am not interested about the title of the property. I am interested about the premises possession of the property. That was the case.
No, what the case is made out by the plaintiff.
Yes.
What case was made out? Treating you as a tenant under him, treating you as a licensee under him.
No,
What?
we said she is not a tenant at all.
No.
Our case, my lord, the appellant before your lordship of the successive purchasers
Of
that particular property.
From whom?
The property given to the son.
No, from whom?
My lord, from the persons, my lord, to whom the property was given, that is son and son's other heirs.
Let us understand the things. Property, correct me. In my own English,
my lord,
bad English, I am just saying. Property, say, belong to A.
Yes.
A executed a will.
Yes.
Bequeathing his property to his son.
Yes.
The son is a sole beneficiary and he applied for probate.
Yes.
In the meantime, one of the shop in the property is let out by the wife of the beneficiary.
Yes.
To the plaintiff.
Yes.
The wife was realizing the rent from the plaintiff.
Yes.
Plaintiff in turn inducted you in the property.
Yes. Plaintiff's son did not.
No, plaintiff.
Plaintiff, yes.
Plaintiff inducted you in the property.
Yes.
In therein. Now you purchase the entire share of the owner.
Yes.
Means either the sole beneficiary or through his heirs, whatever.
Yes.
You purchase the entire share. So you have really stepped into the shoes of a owner.
And during this period, my lord, a partition suit was also filed by some other, my lord, the heirs. The partition suit was also pending.
Then you purchase what? The entire share or what?
No, one shop room. One shop room, not the entire share.
Still, I'm
It was a premises whereupon number of shops were there.
So will
One of the shops we have purchased.
Will was in respect of that shop room only, or will was in respect of the entire property comprising of several shop rooms?
Yes.
I'm just asking.
Yes. My lord, we have purchased one shop room. In respect of which, my lord, that particular so-called tenant.
I'm just trying to trace the title in that regard.
Yes.
Again, I'm asking, will was only in respect of this shop room, or will was in respect of the entire property?
No, not the entire property, the shop room.
So the A was owner of only shop room.
No, he was owner of the entire property. Whereupon number of shop rooms.
It was a gift restricted to this shop room. Sorry, I mean will restricted to this shop room. That
entire property. The will was in respect of the entire property. The will was in respect of the entire property.
That is what I asked you, Mr. Ali, that whether the will executed by A was in respect of the entire property which comprised of several shop rooms, including the one, or it was only restricted to this shop room.
But the will was executed in respect of the entire property which belonged to A.
No difficulty. No difficulty. And by virtue of this will, the son of A is a sole beneficiary.
Yes.
Probate granted.
No.
Till not granted.
Not probate was not granted because later on it transferred that the signature was not correct. Therefore, the probate was not granted.
Rejected. Application for probate was rejected.
Rejected.
Rejected. Now, what is a fallout?
It is the wife of the prospective.
No,
wife of the prospective
no.
beneficiary.
Uh,
My question is, wife of the prospective beneficiary.
I will come
Can
to
she
you.
give?
I know.
Can-
I will come to you and tell you a judgment of the Supreme Court.
Yes.
And our High Court has judgment. That's why I just try to. First thing is that the facts has to be very made clear.
My lord.
I understand
Yes.
the point. Let me first clarify the facts.
Yes.
You purchase from the son this shop room.
One of the shop room.
This shop room, I said. I did not say
The shop room which is in dispute.
You purchase this shop room from the son.
No, not from the son.
Then from whom?
Not from the son.
Then from whom?
I purchased, my lord, it is from the successors of the.
But who are the successors? The son is also a successor. That's why I'm asking you.
Yes.
Who? Who has sold you? I just wanted to know.
Yes.
Hmm?
Yes.
আমরা কিছু আপনার ছেলে আমরা কিনেছিলাম আপনার ছেলেটা বিক্রি করেছে।
He's also representing.
Yes. My lord,
Yes. He's also appearing.
Yes,
Oh, your presence is very much necessary. Don't worry.
My lord, the son sold to someone.
Son sold to someone.
Yes.
This shop room.
Yes. From him we purchased.
From whom you purchase.
Yes.
No problem. So, only successor of A was son.
Yes.
There was no
No,
other
there
heir.
are other successors. That is why the partition suit.
Partition suit, the preliminary decree has been passed.
In partition suit is still pending, not yet.
No, no.
It's
Pending will
Partition suit is
remain.
back on the
Preliminary decree passed.
partition suit is still pending.
No. Preliminary decree means it will not come to an end, sir.
Yes.
It will remain pending.
Yes.
There are two stages in the partition suit.
Yes.
One is a preliminary decree stage. Thereafter, the final decree stage, the suit would remain pending even after preliminary decree. That's why I'm asking you. Preliminary decree is passed.
But my lord, my submission is, my lord, what struck to me. Can the wife of, my lord, a prospective beneficiary induct a tenant in the property which will belong to the son? And can he claim under that title that he is a tenant and therefore the court will pass a decree in his?
You want to answer? That's why I said.
Yes.
And the immediate junior is very important.
My senior. What he will be.
Where is the difficulty?
Pardon?
Tell me, where is the difficulty?
Yes.
I tell you, there is a judgment of our High Court in a similar situation. And one of the judge or the division bench has held what you say.
Yes.
This was upset by the Supreme Court subsequently. The parent judgment which was relied upon by the division bench was 49 CWM. And thereafter the division bench held.
But wonder that question was not gone into at all.
That is what is. I am telling you. What was that case? Husband was the owner. I am talking about that case. Husband was the owner. He permitted the wife to
Permitted.
Yes. There is no case which is coming out as of now. Permitted the wife to look after this shop. There is no document which is forthcoming in this regard. The wife inducted the tenant. And thereafter, a suit was filed by the husband against the wife. Got the ex parte decree and wanted to execute the decree, evicting the defendant therefrom, inducted by the wife. He took a plea. No, you can't. I cannot be evicted. Sham transaction. On the basis of 49 CWN, it was said that yes, sham transaction, which was relied upon by a division bench. I'm not going to say who presided over the division bench. Your junior is well aware of. Admitted. Yes, can't be done. But later on, when my matter went to the Supreme Court says there is no fetter in this regard. You are bound to go out. Go out. So Whether the wife had an authority to induct plaintiff is immaterial.
Yes.
The moment one fact became certain that the wife gave possession to the plaintiff and plaintiff was enjoying the possession. And if the plaintiff has given you a possession, as you said, that he was inducted, then in that event, under section 116, you can't say that at the time when the tenancy was created, the plaintiff did not have any right, nor he can derive any right in respect thereof. Because your possession flows therefrom. Now, only question is, now you have elevated your status. Now you say that I have become owner. But still, when there is a intermediate rights, what would happen to that right? Whether that would evaporate, that would go, all these things are required to be considered in this way. Law says that even if you have acquired the ownership, if there is I know the latest judgment, don't say no, 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 I know, but there are a silver line in between that. Very recently, 1 week before, there is one judgment has come, I know.
বল না
না না
মানে let it-
না no no no
let it-
no 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 কখনো না।
কেন?
আমি তোমাকে কখনো
Supreme Court কি বলছে?
ক্যান এলিভেট মাই আমাকে বেরিয়ে গিয়ে আমাকে মার্জার হবে। তো আমাদের কেসে এটা কতটা হবে তুমি একবার দেখে তারপর আর্গুমেন্ট। But then unfortunately ওটা এখনো রিপোর্ট হয়নি। Unfortunately.
No. But in this manner, in the case manner your Lord says, I could understand that the husband permitted the wife to induct the tenant.
No. That was a ground for eviction against the wife.
তুমি জাজমেন্টটা দেখে তারপর আর্গুমেন্ট।
That is why the division bench held that it is an alter ego.
Well, the tenancy should be a legal tenancy.
Because it's a collusive decree, sham decree obtained by a husband against a wife. And the ground was no permission to sublet.
Especially when there was no divorce proceeding going on.
Yes, nothing of the sort. But then, my lord.
Relying on 49 CWN is a parent judgment.
Yes.
Relying on the 49 CWN, the division bench said, but later on, the Supreme Court took the another view against that judgment.
এখন কি হবে? হ্যাঁ? দেখে নাও। এখন আপনি অ্যাডমিট করবেন?
Situation. See that?
টেনেন্সিটা তো লিগাল টেনেন্সি হতে না হবে না। এটা
Absolutely. Legal tenancy না হলে কোনো রাইট
that is what I am saying. লিগাল টেনেন্সি হতে গেলে তো প্রপার ওনার আগেই তো টেনেন্সি করতে হবে। এই কোশ্চেনটা তো অ্যাড্রেস হয়নি কোথাও। এই কোশ্চেনটা কোনো কেউ ডিসাইড করেনি।
যার রাইট ছিল না সেটাই তো ডিক্লেয়ার করেছে।
That is what I am saying. Yes. আমি তো বললাম না আমার অ্যাপিলেট।
What is the status of private? Interesting.
My submission is, my lord, that the tenancy must be a legal tenancy. And the legal tenancy, as far as my understanding goes, my lord, it is the real owner who can induct a tenant, a premises tenant.
Let us understand the definition of a landlord, sir. Whether it contemplates such a situation. Let us see. Let us see the definition of a landlord. Sir, it is defined in 2C. It says in landlord
Yes.
includes any person who for the time being is receiving. Receiving.
Yes.
Or is entitled to receive, or it's a disjunctive, the rent for any premises, whether on his own account or on account of,
Yes.
or on behalf of, or for the benefit of any person, or as a trustee, guardian, or receiver for any person, or who would so receive the rent or be entitled to receive the rent if the premises were let to a tenant. So, if the moment it appears that he is receiving the rent.
No. And that is the proof that was needed to be given by the plaintiff himself. That the plaintiff has to go.
Plaintiff has inducted you. What is the meaning of the word? Tenancy has not been defined anywhere.
No.
Any act. One can borrow.
Tenancy.
Yes.
It's a declaration of tenancy.
Yes.
One can borrow an expression.
No, the tenancy, my lord,
From section 105 of the Transfer of Property Act in relation to a lease. The same concept.
Yes.
Only difference is certain protection has been given to such a lessee.
And his case that he is a premises tenant.
Correct.
He's a premises tenant.
Correct. So he comes under the purview of this act.
Yes.
It does not contemplate that a person who inducts a tenant should be a owner of the property.
But he must accept.
The landlord, the word a landlord is defined in such way that any person who is receiving or entitled to receive, even at the time he does not have a right, but what he has is the possession which he parted with.
My lord, the tenant, my lord, the landlord must accept, even by authorizing, even somebody else is authorized by the landlord.
No, that's why I say he is receiving. The word is receiving.
He did not.
He inducted you.
It is the wife taking.
A wifey. I am talking about wife being the landlord.
Yes.
I am talking about the wife being the landlord.
She is not.
She's
Property
satisfying
belongs
the
to me.
definition of a landlord.
My lord, I am the owner.
Receiving a rent from you.
During my lifetime.
Immediately she gave you a possession.
My lord, during my lifetime, can the wife become a owner of the property?
Not necessary under the West Bengal Presidency Act, sir.
Under the Premises Tenancy Act, my lord, the wife, if authorized by me, can accept.
Then the word is receiving. Please, you don't have a book. I think it at the end. We have another book.
Jesus.
Give. We have another book. We can share. Look at the definition of a landlord.
Yes.
Landlord includes any person, does not qualify owner.
Any person who?
No. Then Who means what?
Yes,
Who is
any person
relatable?
who.
Who?
Now thereafter, the
Now,
description.
that's why I'm saying who
Yes.
means relatable to that person. Any person who means that person. That any person who for the timing is receiving.
Yes.
Now, what is the word?
Who for the timing is
I
receiving.
am receiving a rent. I am receiving a rent from a tenant. Whether
Tenant.
I should be the owner of the property.
Yes, but the tenant means any person. Tenant is defined.
Yes. I am saying tenancy is not defined.
Not tenancy.
That's why I'm saying tenancy is not defined. Tenant is defined. Premises is defined. Ironically, there is no definition of tenancy anywhere in the statute. Then that's why I say one has to borrow the concept of tenancy. What does it mean from Section 105 of the Transfer of Property Act in relation to a lease? What does it mean? What tenancy means is the transfer of use and enjoyment of the property in lieu of the consideration which may be called as a rent. That is what is defined under Section 105.
But even without even without having any right.
Necessary. That's why Section 116 of the Evidence Act says that since you were inducted by a person and took the possession therefrom, you are precluded or stopped from challenging that he did not have a title at the time of creation of the tenancy.
Yes.
What is this Evidence Act says? Let us see.
And that rule of evidence has to be followed, my lord, while deciding a question. While deciding the question who was really a tenant or not. अभी देखिए चीज एविडेंस है ठीक है
No person who came about since of a person and permission shall be permitted to take up. Stop it. What can you say? Remember, from here, she must have said, what if I doesn't she come up?
law of evidence are not.
The 116 law. 116 of the evidence.
You did, man.
Stop.
Evidence
With
act.
them.
Hold. No, no. Transfer of property.
No. Evidence act চাই।
Yes. Yes, my lord.
At the bottom.
180. My lordship refers to 116. Yes. No tenant or immovable property or person claiming through such tenant shall during the continuance of the tenancy. The question of a tenancy has to be determined. My submission.
What
Be
defense you have,
permitted to deny
what defense you took, sir?
that the landlord of such tenant.
I'm asking what defense you took in the suit when the suit for eviction is filed against you?
I took my lord that he is not a tenant at all.
No, you. Who are you in the property?
I'm a subsequent passenger from the
When your induction was done, then what was your status?
The original, the original owner has sold to someone
I am
from whom I
asking, sir,
purchased.
sir, that is a subsequent event. I am talking about a day when
Yes.
you were inducted
Yes,
by
and
the
also,
wife. In what capacity you were inducted?
my lord, the property, my lord, I have purchased from a person to, my lord, let me submit, my lord. Let me submit. Let me submit. The question is, the tenant, the so-called tenant's case was as a plaintiff. His case was that there was an injunction, and during the period of that injunction, the property has been transferred. Therefore, it cannot be transferred, and any subsequent purchaser has got no right. That was, my lord, throughout the gamut of the entire proceeding before the.
Sir, this suit is for eviction. This suit is for eviction, I believe. You started that the suit is for eviction.
গন্ডগোল হয়ে যাচ্ছে suit for eviction.
No.
Oh, you have started.
I've said, my lord, the Specific Performance Act. Maybe should subject.
No, not suit.
A declaration of tenancy.
No, right.
Suit for declaration of tenancy.
Evict or disposes the
বলাই যাচ্ছে না।
from making any damage.
My lord, my application in page 2, I have given the entire, my lord, the prayer of the in the play. A decree of declaration that the plaintiff is a premises tenant in the premises in suit.
আর জজ সাহেব যা বলেছেন সেগুলো আমার ফেভারে।
Yes.
তখন জজ সাহেব যেগুলো বলেছেন সেগুলো সব আমার ফেভারে বলেছেন।
তাই তো।
Really? One exit.
Cheers.
এই দেখো রিপোর্টের
আচ্ছা।
দেখো amendment.
नहीं। नहीं होगा।
ठीक 33
हाँ। Memo of Appeal, page 33.
Memo না, appeal court এর judgment.
Appeal court.
Should I bar under 34? Position a new position চাইনি।
Achain. Thank you.
চাইনি।
Page 27. Page 27 of trial court. দেখি না। দেখুন, 27 নম্বর। 28 27 yes. And 80.
No, this is the substantial. The suit itself is not painted. Jai is admittedly not in possession and he has not paid for recovery of trial. Appeal court বলছে তো হয়েছে হতে পারে করে দিবে এটাই বার আন্ডার 34 ওয়ান সেকেন্ড হলো যার কাছ থেকে টেনেন্সি নিয়েছে যে বলছে নাকি এক্সিকিউটর সেই এক্সিকিউটর সেই বিলটা প্রোভেট হয়নি তাহলে যে ওকে ইন্ডাক্ট করছে তার কোনো রাইট নেই টেনেন্ট হতেই পারে না আমি যদি আজকে এখানে তোমাকে ইন্ডাক্ট করি টেনেন্ট হয়ে যাবে দিস ইজ ইয়োর
হয়ে গেছে পড়া পড়া হয়ে গেছে Section 34, 34.
Thank you. I have read the whole. Now I understood what is what. Now certain.
Your Lordship has gone through the judgment of the appeal court.
You are, yes.
The appeal court. And on the trial court judgment, Your Lordship will kindly come to page 27. Or whether the suit was maintainable at all. Trial court judgment, kindly Your Lordship can assist.
What is that? Section 34.
My lord, the
What
question
it
is,
says?
my lord, the tenancy has to be established that the tenancy was created in accordance with law. And that if it is, my lord, a case for recovery of possession under the specific relief act, there must be a definite plea. There must be a prayer for that. Admittedly, there was no prayer for that. Admittedly. My lord, there your lordship will kindly see, my lord. This is there at page 33 of the appeal court judgment. Though there is no specific plea in the plain as regards the recovery of possession against the present appellants, in view of the above discussion, this court is also of the view that the same is not required under the law. Whether this is correct or not. My second question is, my lord, that if it is say, my lord, the trial court says,
Where
it is a
plain?
fact that the defendants are in.
Is a plain as amended?
Pardon, madam?
Prayer is not there.
No prayer.
That's the finding.
Where is the plaint?
The application.
In the application, it is there. I've said it out.
There. Tell us the
In the application,
page number.
page 2. Well, in the application, page 2, page 2.
The set out was.
Yes.
Lordship, take the section.
Plaint.
Sir, it is there by way of an amendment. C1.
In my copy then.
Please.
Finding of the appellate.
Please come to page 20. Not necessary.
Suit
C1.
filed by 24 injunction.
Page 20. Prayer C1.
ডিগ্রি হয়নি ডিগ্রি দেয়নি
ডিগ্রি
দেখো তুমি কোথায় ডিগ্রি দিয়েছে রিকভারি অ্যাপ্লিকেশনে ডিগ্রি দেয়নি
No, then.
Yes, yes, it has been granted. Granted, sir. Granted. Your junior has not read it properly. He needs revisitation of the entire brief.
This is the one.
Yes, yes.
Trial court, trial court. Yes.
ট্রায়াল করে যাও পেছনে
In the trial court?
পেছনে যাও ডিগ্রিটা কোথায়
Yes.
Ah.
With that.
ঠিক আছে তাহলে অন্য পয়েন্টটা বলো
Your junior has not read the brief
No, no, no.
properly. He needs revisitation.
No,
অন্য পয়েন্টটা বলো
no. But my lord, the question is, my lord, therefore there must be a specific prayer. If
There
it
is
is
a specific prayer. C1.
specific prayer. My lord,
Yes, for recovery of possession.
yes, but the other
Yeah.
point is, my lord, if it is a tenancy, he claims that it is a premises tenant. The premises tenancy has to be created in accordance with law.
Yes.
And if he claims, it is his case, that well, he was inducted there as a tenant by the wife of the prospective owner, not with his permission or his authority, or that the amount of the rent, so-called rent, has been deposited in his account. Nothing of the sort. So,
Rent receipt signature.
my lord, no, my lord, that is also
You're talking about Urmila Bagh. I know. Then
my lord, in the
প্রিন্টেড এখন সেকেন্ড প্যারাগ্রাফ
কোনটা বলছিস?
প্রিন্টেড সেকেন্ড প্যারাগ্রাফ
Page 14. Yes.
about temporary receipt tenant. Just because there's a receipt doesn't mean he's become a tenant. The plain.
Okay. Application for injunction. Yes. Yes.
This is how you've been inducted.
Yes. এখানেই বলেছো। এখানে বলেছি না।
রাইট করছি সেখানেও বলছি সেখানে বলছি ইট ইজ কামিং ফ্রম দি alleged will dependent in the right of will.
Alleged to have been. Yes, it is. She must be inducted to one of them. ও কি বলতে চাইছে? কি হলো?
এতক্ষণ ধরে কি করছে?
এই যে উর্মিলা।
আর কাছে
উর্মিলা হচ্ছে ভারতীয় হচ্ছে
তুমি অ্যাপিল করে ২৭ নম্বর পেজ করো।
did not have
refinement of the number paragraph.
I think please further revisit the entire matter. Come and read those line of judgments as well.
My lord, for a moment, my lord, you're
And another judgment, I am just giving you all the judgments. There is another judgment is of Justice Anil Kumar Singh, Division Bench. 85 Calcutta, AIR 1985 Calcutta.
85 Calcutta.
I'm just recollecting the name. Just now I'm aging. I'm frequently forgetting.
That's my email address. Aging lawyer.
It's not a tide water, or it is a tide water. Either it is a tide water. I'm sure it's a AIR 1985 Calcutta or AIR 1982 Calcutta. These are the two I have. I do not know. My strong gut feeling says that these are the two judgments. What has happened there is that the same thing happened, like the one which has happened. Tenancy in between. The person who has was inducted became a owner thereof, and then he stopped this one. There was a decree which was passed against that, but the decree could not be executed fully. Question was entitled to receive the rent. Was the question.
Induction of?
Receive the rent. That was held that no, so long he is not thrown out, he is entitled to receive rent. You can't deny that he has gone. Title paramount was also argued there, which was not accepted. I'm just forgetting the name. Tidewater or not Tidewater or another one. Ganesh Trading Company. Ganesh Trading Company. Please read that, and argued by none less than Mr. Shaktinath Mukherjee and Mr. Sudhir Dasgupta, both sides.
But in the meantime,
argument that was advanced. Do it.
Execution proceeding was on.
Please take that decision. Please read that decision. You will understand. When you want.
Execution proceeding is on.
What is the date?
Tomorrow.
For?
The execution proceeding, my lord.
For what?
I do not know.
Nothing is going to happen. Yes.
We can come.
Can I fix it tomorrow you want, or Monday?
Monday করে
Monday?
Monday.
আমার সঙ্গে আমি একটু ডোমিনেট বসে
Monday?
Let this matter be listed on Monday.
Any.
It's called the one original side matter is there, supplementary. Have you notified it? Who is appearing?
তোমাকে একটা নোট করে তোমাকে
Who is appearing?
না না কিছু কথা
Rai and Company. I do not know. That's the advocate and records name.
রাইয়ান কোম্পানি মিলার সন্তোষ রায়
I do not know. I do not know all these names.
সন্তোষ রায় মিলার নো রত্নেশ আমি তো আমি কিচ্ছু করতে হবে না তোমার করে দিয়ে he belonged to Khaitan company. Definitely, my lord, he was being Ratnesh Rai, definitely.
He was there in
Khaitan.
Yes. Shift over.
Shifted out. না না আমাকে এই যে আমাদের check card.
Mr. Raghunath Banerjee, then Mr. Raghunath Mishra. Spiritual with the bar association. Can anybody contact these persons? Otherwise, there will be a difficulty. Mr. Ratnanko Banerjee and Mr. Abhijit Mitra.
ठीक टाइम नहीं है हैं? सब आगे
Can anybody? Well, Mr. Chatterjee has gone. Can anybody contact Mr. Ratnanko Banerjee and Mr. Abhijit Mitra? They are appearing in the matter. Now she has come rushing. Madam, why you do not appear? The matter is finished at 3 p.m. today. The notice was given to everybody.
Lordship, I'm read by Mr. Ratnako Banerjee, Your Lordship. He's on here.
Where is the other side?
I'm sorry, my lord.
Where is
Actually, I don't know, my lord, they are not here. This is assigned to your lordship.
has been assigned?
My lord, my lord.
Interim order is still tomorrow.
Yes, that is,
Why we listed the matter at 3 p.m.
my lord, sorry, we missed it.
Other side. You were given a notice, supplementary affidavit. The supplementary list is published on the website.
My lord, my lord.
So,
It was,
why you will not come at 3?
my lord, sorry, we missed it.
Where is the other side?
They're not here, my lord. I don't know what happened to them.
You have to contact the other side.
My lord, may I give notice to them for tomorrow and come back? Or I don't know whether they'll be able to come by this time if I get in touch.
Tell Mr. Abhijit Mitra, Mr. Jishnu Chaudhary, whoever.
My lord, I'll,
No, advocate in the court is who?
Fox and Mandal, my lord.
Or tell them to immediately come.
Okay. My lord, this is my lord, execution proceeding in which order was passed by the court asking for some part of the award to be executed, my lord.
What is that about?
Award was, my lord, award was, my lord, is a award in declaratory nature, my lord. The award I'll come to that.
Not executive.
My lord, I'll come to that, my lord, because my lord, the award contemplated as per the 5E of the award, clause 5E of the award, there was to be a family arrangement to be executed, my lord. This award was of 2010, my lord, and that family arrangement was executed in 2010 itself, my lord. And all other party, including some of the party, those who were not party.
Why this matter is listed? It has been assigned to
My lord. My lord.
The interim order is still
I appreciate, my lord.
not available from tomorrow.
My lord, my lord, my lord.
There are two ways.
My lord.
Either if they come, we can fix the matter on some other day. That is in the next week.
If your lordships kindly extend it.
That is why I want. Then we have to extend. If it is not possible, then I am releasing here and now so that at least.
No, that your lordship will not do. I am trying to get them contacted, my lord. Give us 5 minutes, my lord. I'll just be back. Just be back, my lord.
I am releasing it. Let another page.
No, my lord. My lord, it will be very difficult, as you know. Lordship knows that it is going to expire tomorrow itself. So
that is what we find from the
my lord,
order.
Very true, my lord. It is there. It is there, my lord. The order is there, my lord. Just call, if I can go and out call them, my lord. They are coming, my lord. Sorry.
আমরা চলছে। That we are releasing. If they
My lord, I just spoke to them, my lord. They are sending their junior.
Sorry. Then just the section carried out by the defendant, but there was an urgency and this matter was fixed today on 27th after supply.
maybe tomorrow the page will be there, you can.
My lord, my lord.
I spoke to the other side, my lord. They said, let this matter be fixed any other day. They are sending somebody, some junior, but they said that it can be fixed any other day. In the meantime, your lordships can extend the order and fix the matter, my lord, for final hearing. I just spoke to them. Iram is the advocate on record on. Where is she? She's come. I spoke to her personally, my lord, and she said, they said they are coming, my lord. I don't know where are they.
All your side has come for one good reason.
I don't know, my lord, but we tried to contact them. We are asking, requesting them to come, but I don't know why they are not coming. You are for the box. Yes, yes.
No, the other side is here. But kindly fix.
Signed today. And it appears that the interim order is still tomorrow.
Lordship, does
We didn't see the supplemental list. Do you apologize for the miss, Your Lordship? We didn't
We
see the
have already published.
assignment was seen by His Lordship. The supplemental list we didn't missed out.
It was published in the official website. It was given a notice in a bar association, bar library club, everywhere.
Your apologies, Your Lordship.
Why it is not there?
Fix date fix Fixed, Your
So what to do?
A date be fixed, Your Lordship, for here.
When?
As Your Lordship pleases.
You tell us.
Lord, after 12th March, Lord, 12th.
You say when?
As Your Lordship pleases.
You say here now we are fixing a date. Argue. Tell us the convenient date.
I'll tell Your Lordship.
12th করে 12th March, 13 March.
12th March করে না কোনো
12th March, Your Lordship. 12th March.
12th March is
Tuesday, my lord.
Tuesday, Your Lordship.
11th?
Yes.
Lord, 11th,
Oh, no, my
Lord,
it's not there.
Lord, 11th, my lord, I have some Lord, difficulty. We are for the appellate. 12th or 13th, my lord, whatever. 12th. Oh, sorry, my lord. Oh, 12th. Oh, so sorry, my lord. 13th. I'm so sorry, my lord. Thank you. I'm so sorry, my lord. 12th is gone. Sorry. I'm so sorry, my lord.
4th March, Monday.
My lord, my lord, this is, my lord, that will really come up for hearing.
Today itself because the interim order is still tomorrow.
It's, my lord, really, my lord, it's question of, my lord, hearing the appeal out. I'll tell my lord, it's a question of, my lord, no, my lord, I'm saying, my lord, it's going to be, whenever, my lord, it comes up, that I know, my lord, I'm not, my lord, worried about, my lord, that. My lord, 13, my lord, we were praying, my lord. We'll come ready, my lord, for the final hearing, my lord.
13th, Your Lordship. No problem.
13th. Then 18th.
Very well, 18th.
The interim order takes
Interim order, my lord, will have to be, my lord, extended.
You have given an undertaking?
That will be extended.
তারপরে হঠাৎ দেখে দেখছিলাম
in the supplementary list as the interim order was operative to then both the councils. This is a matter of 18th to be taken up
Well, whatever, my lord, is convenient. Anytime.
30 or 2, whatever.
Whatever, my lord, 2 o'clock, 2 o'clock, 2 o'clock. Grateful.
The interim order till 18th.
My lord, so 18th, my lord, maybe 19th or 20th, my lord. 18th থেকে কিছু হলে আবার আমি what for the 18th of 10